Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In the last video, we have discussed the case of the state of Tamil Nadu versus the governor of Tamil Nadu and another, where it was alleged that the bills were not being cleared. Another issue has come before the Chief Justice. Same bench. Chief Justice Dr. D.Y. Chandrachud, Manoj Mishra and J.B. Parthiwala. Right? This is regarding the so-called Banwarilal Purohit. I will read the case law first. The state of Punjab versus Principal Secretary to Governor of Punjab and another. State of Punjab versus the Principal Secretary to the Governor of Punjab and another in WP Civil number 1224 by 2023. So of course it is also once again notices were given to the other party. But here please remember the Honorable Supreme Court of India bench clearly said on November 10th, yes, they have given the judgment. They clearly stated that it is not open for a governor to doubt the validity of the assembly sessions. What is this? Validity of assembly? The governor has got a doubt. So normally we all know that the assembly should be convened minimum 3 times in a year with a gap of 6 months. Budget session, monsoon session, and you can call it as winter session. 3 times you should be there. So normally the speaker, since he is the leader of the assembly, he will prorogue the assembly. He will declare the assembly is adjourned, sine die. Next date he will give. But in Punjab, a peculiar thing is happening. The budget session is continuing. Budget session normally it closes by March. But it continued in May, it continued in October, like that it is continuing. Now the governor has got a doubt whether the bills passed during this particular session, they are valid or not. Because the main point is whether the sessions conducted by the assembly is valid or not. That means now the rift is between the speaker of the assembly and the governor. Very peculiar incident. So once again the so-called governor of Punjab, yes, right, governor of Punjab, Banwarilal Purohit, right? The Supreme Court directed that the governor should proceed or should decide the 4 bills which have been submitted to the governor for his assent, for his clearance during the assembly, right? So please remember why the governor has withheld, the Punjab governor has withheld the orders, because he doubted the validity of the duration of the June session of the Punjab Vidhan Sabha. Just now I told you the so-called budget session, monsoon session and so-called winter session. So one session is continuing. Whether it can continue or not, it is for the speaker. It is for the speaker to decide, not the governor. Governor has to give the assent if they want. If it doesn't give the assent, yes, they don't call the speaker, they will continue. Right? It is happening in Telangana also. Now, the Honorable Supreme Court of India stated that the governor should not doubt the sessions. Governor should not doubt the sessions because the Legislative Assembly is comprising of the so-called duly elected members of the assembly. Right? Now, the governor of Punjab must proceed to take a decision on the bills submitted for the assent. So, because the House was conducted on 19th to 20th June 2023 and it is constitutionally valid. Why? Because the real power will rest with whom? Rest with the elected representatives, not with the governor. That's why I call it as de jure. De facto, the CM, right? And of course, the court also wrapped the state that the assembly cannot be kept in suspended animation permanently. Now the word. Honorable Chief Justice of India used the word. The governor is playing with fire. The governor, Chief went on to extent of saying that the governor was playing with fire by withholding the assent on bills on this ground. He has already questioned, how can you say that the bills passed by the assembly cannot be valid because the assembly sessions itself is valid? The governor, you realize the gravity of what you are doing? You doubt the assembly sessions? You are playing with fire. How can the governor say that the bills are not passed by the elected members? If that is the case, will we continue in a parliamentary democracy? Very, very serious matter. If we give such power to the governor, definitely we will not continue in a parliamentary democracy. So this is the main problem. Anyway, with this you can understand that governor has to clear the bills. No doubt we have discussed the pocket veto of the President of India. Like that they can, but they cannot sit on the files for years together. Right? So this is another classic case regarding the governors. Right, in the constitutional law cases I told you about 2 or 3 years back regarding DC Wadhwa versus State of Bihar, where the governor has given a number of ordinances which he doesn't know. That is also not correct. Anyway, as far as this is concerned, the governors has to take immediate decision on the bills submitted by the state. This is what you have to learn. So please read the case law and enrich your legal knowledge. Thank you.